case briefs, and so much more. LSData's got what you're looking for.
The 1977 landmark case of Bates v. State Bar of Arizona examined whether attorneys can advertise their services, with the primary caveat being that such advertising remains within the parameters of not being false, deceptive, or misleading. Regulating attorney advertising emerged as a means to protect consumers from harm. Two Arizona lawyers, John R. Bates and Van Osteen, found themselves at the center of this crucial dialogue when they publicly advertised their affordable legal services in a newspaper. This violated a stringent regulation by the Arizona Bar, sparking a debate on the potential infringement of the Sherman Act and the First Amendment. Both attorneys previously worked at the Maricopa County Legal Aid Society and had recently set up their own legal clinic to provide affordable legal services to the middle-income segment. They built their practice on handling routine matters to keep costs low, relying on high volume to subsidize their low return on individual cases. In the initial hearing, the Supreme Court of Arizona dismissed both claims, a decision that allowed the state bar's regulation to stand, save for a minority dissent from Justice Holohan. This marked the beginning of the duo's legal battle, which would see their case ultimately land in the Supreme Court. Upon review, the Supreme Court opined that the ban on advertising by attorneys infringed on the First Amendment, as it damned the free flow of commercial information and kept the public unenlightened. Rules preventing pharmacists and attorneys from advertising were labeled unconstitutional, marking a significant win for Bates and Osteen. The ruling permitted attorneys to publish truthful advertisements about their services whilst being cautious to stipulate that false or misleading advertisements would still face regulation or restriction. Thus, the Supreme Court of the United States' final judgment straddled both affirmation and reversal. It affirmed that the Sherman Act's protection could not be extended to a state-imposed ban on the advertising of legal services, while simultaneously reversing the lower court's decision that the bar's disciplinary rule was consistent with the First Amendment. A fresh precedent was set, facilitating a more transparent conveying of legal service possibilities.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.